This is a training to review the purchase agreement that is used by agents at Resources Real Estate. This agreement is published by the New Jersey Association of Realtors. It's used by many companies, but not all companies. It's not required that you use this version of the contract. However, it is fairly common. You'll notice at the bottom of the page, it says New Jersey Realtors Form 118 statewide. This is the date. So this was most recently updated January of 2018. That's the one that we're going to be reviewing here. So first of all, I encourage you to read through the entire agreement, flag anything that you're not clear on. You are not an attorney. You are not representing yourself as an attorney. You are not explaining the contract as an attorney would. However, you should be familiar enough with the contract to be able to explain what various components of the agreement mean and be able to explain in a layperson's language so that a buyer or seller can feel comfortable in signing the agreement. And remember that in New Jersey, because of attorney review, both parties have the ability to have an attorney look at the contract and advise accordingly. And only after the two attorneys have signed off on it will the contract be binding. So it's not like there's no recourse to make any future changes. First off, page 1, this is called Opinion 26, Notice to Buyer and Seller. This is required by law in New Jersey to have this attached to any residential real estate sales contracts. Long story short is it identifies, first off, who the broker who is writing this contract represents. So you'll see representing the seller, not the buyer, not the seller, both the seller and the buyer, or neither the seller nor the buyer. This should clearly reflect whatever is in your consumer information statement. And if you are filling this out, typically it's the buyer's agent who is going to be filling this out. You would be filling it out as you represent the buyer, not the seller, or both the seller and the buyer, if Resources Real Estate is the broker for both parties. So notice I'm not saying the agent, but the broker. So dual agency, which is what this refers to here, is when the brokerage, Resources Real Estate, represents both the buyer and the seller. It doesn't mean just the agent, it means the company. So it could be two agents who work for Resources Real Estate in totally different offices. That's considered dual agency. And in that case, this checkbox here would have to be checked off. Otherwise, you're representing most likely just the buyer, not the seller. Neither the seller nor the buyer would be a transaction brokerage situation, which we don't engage in, so you wouldn't be checking that. The rest of this is basically just advising the client that if you want legal advice, you need to hire an attorney. No one other than attorney can provide you with legal advice, not the title company, not the agents involved. So this is basically just detailing why you as a buyer would be smart to have an attorney represent you, and why you as a seller would likewise want to have an attorney represent you. This has signatures for both buyer and seller and both agents. So the selling broker is not the same as the seller's broker. The selling broker represents the buyer. The listing broker represents the seller. We have been given a clear indication that you as an agent, even though you are not the broker, are able to sign this. Technically, I suppose you could also just type in the name of the brokerage, and this is prepared by. So this would definitely be your name here as the real estate licensee preparing the contract. Because it's a fill-in-the-blank contract, agents are legally able to create the contract. So basically, you can fill in the blanks, but you shouldn't take the liberties of adding or changing a lot of things at the risk of practicing law without a license. So you'll see in this contract, first off, again, it's written by the New Jersey Realtors, or the New Jersey Association of Realtors. You have an indication here that this is for use statewide in New Jersey. It says also that this form may be used only in the sale of 1 to 4 family residential property or vacant 1-family lots. This form is suitable for use only where the seller has previously executed a written listing agreement. So technically, this is really not suitable for a contract that you're engaging with an unrepresented seller or for sale by owner, because no listing agreement has been signed, which is attesting to certain conditions, including the real estate commissions. If you are engaging in a transaction as a buyer's agent with a for sale by owner, you will want to have, if nothing else, a permission to show form, which clearly states how much the seller has agreed to pay in commission, and that would have to be signed by them. So you'll notice also it says this is legally binding, a legally binding contract that will become final within 3 business days. During this period, you may choose to consult an attorney who can review and cancel the contract. See section on attorney review for details. So we'll get to that later, but the important thing is that if no attorneys are involved, after 3 business days, it's binding. If you want to void the contract for whatever reason, it has to be done by an attorney. The principal, buyer or seller, cannot simply write a letter declaring it null and void. You need to have an attorney to do it. An agent can't do it. Always make sure that you have an attorney involved to cancel the agreement. Table of contents just runs down all the various different paragraphs, kind of self-explanatory. The parties, you've got the buyer names, and keep in mind you want to have all the buyer and all the sellers who are associated with this agreement. Anybody who appears on a mortgage pre-approval would have to be listed here. And anyone who's on title as an owner should be listed as a seller. Their addresses are indicated. The property of the property address of the property that's being purchased is indicated, along with the municipality, the county, the block, and the lot. So the breakdown of the purchase price comes next. So you're going to put the total on the first line. The initial deposit, which is also referred to as earnest money, is no longer something that we collect. And this is true of most agencies in our marketplace. There are various different reasons for this, but the long and the short of it is we do not require any check to accompany the purchase agreement. The additional deposit, formerly known as the second deposit, was typically collected 10 days after attorney review. This could be sooner if you chose to, perhaps upon completion of attorney review. Some people would choose to have that come in earlier just to make the contract seem stronger, because otherwise you're waiting essentially 2 weeks for any money to come into play. The mortgage is however much mortgage is going to be applied for, at least the maximum amount that would be applied for. Keep in mind when you're putting this together to look at whatever the pre-approval says. If the pre-approval indicates that they have to put a certain amount down, you should keep those same percentages in whatever numbers you're putting in here. If you're putting less than 20% down, for instance, you'll want to make sure that the lender is okay with that. Many lenders will require a minimum down payment of 20%. So just confirm that the numbers or the percentages all match. The balance of the purchase price is basically the purchase price, subtract all of the deposits, subtract the mortgage amount, and whatever is left over is the balance. Keep in mind that a down payment is the total of all the deposits and the balance at closing. It's not necessarily all put up front. So if they're putting 20% down, frequently you're putting 5 to 10% down as part of your additional deposit, and then the balance would be at closing. At the bottom of each page, you'll see spaces for buyer and seller initials. You'll want to make sure that on each page of the contract, your client or both clients have initialed, and all of the people listed here are initialing. Keep in mind that any changes that are made to the contract after it's initially been signed, you will have to make those changes and have them each initialed by both the buyer and the seller to be valid. So, for instance, if you're submitting your initial offer and the seller then comes back with a counter offer and the buyer accepts that, you as the buyer's agent will have to go into the contract, make whatever changes to the price and terms, and then somewhere in the margin, you'll want to indicate where both the buyer and the seller are going to initial those changes, just to confirm that both parties saw that and that they weren't written in after signature. It is illegal to change anything in the contract after both parties have signed and initialed it, unless you have those parties initial it to confirm acceptance. Okay, number 3, manner of payment. So this is talking about the initial deposit, which again, I was indicating was frequently or previously also known as the earnest money deposit, which we no longer collect. So typically you're going to leave this blank because you're not going to have an initial deposit. It's not to say that you couldn't do an initial deposit, but Resources Real Estate no longer collects that and puts it into our trust account. So if for some reason someone required an initial deposit, and typically earnest money was maybe $1,000, but it can be really any amount. The highest amount that I've written a contract for an earnest money deposit was $100,000. Instead of having it held in our escrow account, you would want to place that in an attorney or title company trust account. And typically I would say turn to your client's attorney to hold that. The additional deposit, which is the second deposit, formerly known as the second deposit, is paid by the buyer and held in escrow. Usually this would be 10 days after attorney review, but again, this could theoretically be any date, but to go later than 10 days after attorney review probably would not be looked upon favorably. If you go earlier, that would probably strengthen your offer potentially, or at least psychologically. C just refers to who is now holding the deposit money. Typically, this is going to be held in the escrow account of the seller's attorney. Technically, it could be held in anybody's trust account, the realtor's trust account, meaning the broker, the buyer's attorney's trust account, or the seller's attorney's trust account. But typically, because it's the buyer's money, it's perceived as making more sense for the seller to hold it in the seller's attorney's trust account. So that's what we advise here. This would just say seller's attorney. If there's a mortgage involved, the mortgage contingency is basically saying, I, as a buyer, can buy your property, but only if I get a mortgage. And this is how much the mortgage is going to be. And these are the terms of the mortgage. So is it a veteran's mortgage? Is it FHA? Is it conventional? Is it other? How long? How many years? And what's the payment schedule? And then also in terms of a mortgage commitment, which is basically after the buyer applies for the mortgage, the lender reviews all the documents and says, yes, we approve, we're committing to this mortgage. Sometimes there may still be outstanding conditions. Typically, there are outstanding conditions to the mortgage commitment, and you'll want to review that and make sure that you're clear on what outstanding issues there are. Sometimes it's documentation, sometimes it's further confirmation of employment. Sometimes it's pending a successful appraisal for a certain dollar amount. There's all sorts of conditions that can be placed on the commitment, and you would be wise to review that to make sure that those conditions are being met. Basically, what a mortgage contingency means is because as a buyer, I need financing in order to make this purchase. If I can't get the financing, then you aren't going to hold it against me. Essentially, I'm given a certain time period to get the commitment and get a lender to say that they're going to give me money. And if I can't do that, then I can be free of this agreement. However, this does say that you have to be applying for the loan in a timely manner. So this is saying within 10 calendar days of the completion of attorney review, you as the buyer are going to apply for the mortgage. If a buyer doesn't do that and gets turned down, they may not be covered or protected by this mortgage contingency. So it's really important that you encourage your buyers to make application as soon as possible. Some lenders can even take an application prior to you identifying the property. So you can sort of pre-apply for a mortgage pending the property information. And basically what you're doing is you're supplying all of your documentation, your past tax returns, your pay stubs, etc. That will allow a lender to say, hey, you're good to go. We know that you're a good credit risk. We still don't know what the property is, and we still don't have the appraisal back on that, but otherwise you're approved. And that can really help speed things along. If you don't have the